Good morning. I'm Jasmine Savage, and my PowerPoint begins on constitutional roots. So, in constitutional roots, it's an intellectual property law, Article 1, Section 8, Clause 8, and it can reference as far as back as the Statute of Anne. That was the first actual copyright law or copyright case that was dated early back to the 1700s, promoting the ownership of one's creative works and writing. The 1976 Copyright Act states that ownership initially goes to the author or authors of one's work. And it could also be an object, it could be artwork, it could be songs, it could be anything that is owned by someone else and is trying to be used for the promotion of something else. So, some of the key terms that were in Chapter 9 under constitutional roots were public domain, which is any intellectual property not protected by law and freely available for any member of the public to use. So when using public domain, this could be like, I would say, not a picture off of Google, but if you're using it for personal use, it wouldn't be a copyright issue. But if you was just to use it for, to broadcast an advertisement, that's public use. U.S. Patent and Trademark Office, also known as the USPTO, stands for United States Patent and Trademark Office, which is a federal effect that approves patent applications and officially grants trademark statuses to qualified marks, but only a court can finally determine the validity of a patent or a trademark application. Copyright clause is the clause within Article 1, Section 8 of the U.S. Constitution that authorizes Congress to pass laws protecting intellectual property. And I have a video for you all explaining exactly what it is. It's also Crash Course, something I used to watch in middle school. One of my favorite learning utensils.
Build custom industrial machines in days.
Hi, I'm Stan Muller. This is Crash Course Intellectual Property, and today we're going to be talking about copyright law. As you might have guessed, the law of copyright relates to the right to copy. The copyright as it relates to copies of copyrightable works. You copy? Right, so the right to copy or reproduce copyright-protected works is only one of the exclusive rights granted by the law of copyright. We're also going to discuss what types of things can actually be copyrighted, what we call the subject matter. But first, let's talk a little bit about the history of copyright law in the United States. Why the United States? Not because the U.S. is exceptional and not because I'm a cultural imperialist trying to erode the identity and fabric of foreign nations. Mostly it's just because we're making this video in the United States and copyright law is territorial. So in 1709, England passed the Statute of Anne, which is widely considered to be the first copyright law. The Statute of Anne was the first law to grant ownership rights to individual authors rather than to publishers or printers. Throughout the 18th century, several of the American colonies adopted copyright and copyright-like laws based on the Statute of Anne. The drafters of the U.S. Constitution inserted what is commonly called the Intellectual Property Clause in Article 1, Section 8, Clause 8, and reads, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings." So, listed right up there with Congress's power to lay and collect taxes and to declare war and to gather armies is the power to promote the progress of learning and knowledge through the grant of a limited monopoly to authors and inventors in the form of copyrights and patents. It is, without question, the coolest of the congressional powers. Stan, does that seem biased? Oh, I'm Stan. Mark? Does that seem biased? No? Good. The law has undergone several major revisions in the past 225 years, and it's currently in the process of a major review. So let's talk about what types of works are eligible for copyright protection and what rights authors or owners have in those works. Copyright law protects original works of authorship. Originality in the context of copyright means only that the work owes its origin to the author. That is, it's independently created and isn't copied from other works. How creative do these original works have to be, though? Not very, at all. For a work to be copyrightable, there only needs to be a minimal amount of creativity. Adult judges in court have described it as a scintilla, a dab, even a glimmer. So why is the bar for creativity set so low? Well, it's because lawmakers and judges probably aren't the best people to decide what types of creative works promote the progress of knowledge. Supreme Court Justice Oliver Wendell Holmes said, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits." Holmes may have been speaking specifically about pictorial illustrations in this case, but the principle applies to any type of creative work. Anyway, Holmes clearly feels that judges don't necessarily make the best art critics. So what does Holmes mean by narrow and obvious limits? Well, words and short phrases like names, John Green, titles like The Fault in Our Stars, slogans, One Sick Love Story, fonts, coloring, mere listings of ingredients or contents, familiar symbols or designs like an 8-ball, none of this is protectable under copyright law. Are they protected by any other branch of intellectual property? Ask again later. One quick note, in order for a work to be protected by copyright, it need not in and of itself promote the progress of science. From literary novels to the most graphic pornography, it's probably protectable. The courts have concluded that it isn't a question of whether a work promotes the progress of knowledge, but that all works are granted equal protection. In this way, the law encourages people to create a diverse array of stuff. At the end of the day, it's the system that promotes the progress of science, and not the individual works. Copyright law protects original works of authorship. Works of authorship fall into any of the 8 categories that are listed in the Copyright Act. Literary works are basically anything that can be embodied by letters or numbers, including novels, blogs, computer programs, websites, databases, and possibly really creative tweets. Musical works refers to the actual musical notation of a song by, say, T. Swizzy. Sound recordings are the actual music embodied in the record or the CD or an MP3, and it extends to things like audiobooks. That's what you actually hear. Dramatic works, which are basically stage productions like Wicked or Cats or Waiting for Godot, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and even architectural works. All of these are considered to be writings. Congress has indicated that this list isn't exhaustive, and it's vague on purpose because humans are coming up with new ways to express themselves all the time. Believe it or not, this is not the apex of human creativity. So imagining the Guggenheim or a mime routine as writing can feel like a stretch. In order for any of these works to be considered bona fide writings in the constitutional sense, they must be fixed in any tangible medium of expression, be that a book, an MP3, source code, choreography, a blueprint, or whatever. The only requirement for a tangible medium of expression is that we, as humans, either on our own or by using a computer or some other device, be able to perceive it in the form of a copy or record. This brings up a widely misunderstood aspect of copyright. Copyright protection extends to the intangible material, the literary work, not the physical copy of the work. You may own the copy of the book, but you don't own the copyright. Also, copyright extends only to expression and not to ideas. If you come up with $1 million idea for the best movie ever made or the greatest novel in history, until you actually write these masterpieces and fix them in a tangible medium, copyright law doesn't protect you. And you can't copyright facts. Let's say you do some research and discover that Matthew Buchinger was born in Germany on June 3rd, 1674, without hands or legs. He was a famous artist, calligrapher, and magician. He was called the Little Man of Nuremberg and the greatest German living. And he was married 4 times, fathered at least 14 children by 8 different women. Even if you spend your entire academic career uncovering these fascinating facts, facts alone aren't copyrightable. A biography of Buchinger would qualify for copyright protection, but only the narrative expression would qualify. Subsequent biographers could use the facts you uncovered in your research, but would be prohibited from expressing those facts using your words. They'd have to make up their own. Sans à faire, or scenes that must be done, are not copyrightable either. These are well-worn storylines like a pair of star-crossed lovers from feuding families, or fables or folklore. This sounds to me like a cliche. You can't copyright stuff like the idea of a dastardly villain tying a damsel to a train track. Finally, works created by the federal government can't be copyrighted. That's why we can show you this, and this, and this, no charge! Thanks, federal employees. So who can get a copyright? Well, according to the 1976 Copyright Act, ownership initially goes to the author or authors of the work. One of the only limits to this rule is that the individual author has to be a human being. If the work is created by an entity other than a human, like, say, a monkey or a mindless automaton or an employee, that creator is not an author. I'm kidding, okay? Employees are humans. But that does bring us very nicely to the idea of works made for hire. Let's go to the thought level. So, if your boss tells you to create something, then your boss or the company you both work for is considered to be the author of that something. A work made for hire can be a work prepared by an employee within the scope of his or her employment, or certain works that are specially ordered or commissioned. Many employment contracts spell out what constitutes work made for hire. If they don't, or if there's no clear employee-employer relationship, courts look at things like whether the employee used the employer's computer, created the work during normal work hours, or was directed by a supervisor during the creation process. If it seems...
So that explains deeper into the copyright, also constitutional roots behind the copyright clause. And then now I'm just going to kind of recap what a patent, a copyright, trademark, and trade secret is. So for that, I found scenarios to help you better understand. So for a patent, John invented a new type of phone case that charges your phone with solar energy. This case charges your phone when the back of the case is flipped open to expose mini solar panel. In this scenario, John would likely apply for a utility patent for his invention of the phone case that charges a phone with solar energy. John might also simultaneously apply for a design patent for how the case is designed to flip open to expose mini solar panels. A scenario for copyright would be a library has a book that is out of print and unavailable. The book is an important one in the professor's field that she needs for her research, but the professor would like to copy the books for her files. So this would not be an example of a copyright issue because it's used for personal use, not for like to resell, to advertise, or to promote. For trademarks, I have a scenario, and it's based off a brand behind Netflix, and basically what they did was Massachusetts-based D2 Holdings, they filed a lawsuit against the distribution company, which is the brand behind Netflix, because of entertainment and goods services that they had since 2009. So it was licensed to a gaming radio show not by the name of Granary Media, and they filed for a trademark for the House of Cards because it was premiered and renewed, and it was an infringement case basically for the trademark. However, the failure could be in the distribution company's decisions to change the show's title based on the inability to obtain a trademark. So that would be a way to solve the whole infringement case. And then for trade secret, I use the SpongeBob Krabby Patty formula because when I was little, this is like one of my favorite episodes where Plankton was trying to get trying to steal the recipe for the Krabby Patties. And that's an example